He was a great writer, and his advice to me was, I want you to write it so that your mother could understand it. Knowing that my mother was a high school graduate, he thought people should be able to understand Supreme Court opinions. I think one of the unfortunate aspects of having law clerks is that when justices, as they did for most of our history, had to write all of their own opinions, you got a much more direct sense of what they actually thought about the case. They had to personally explain the basis of the decision. Now opinions often read like elaborate rationales or justifications that have little to do with what actually is moving the decision. I'm not talking about illegitimate factors, but just justices have certain instincts about what would make the system workable, and the opinions that often read like complex law review articles don't seem to reflect the way that justices actually think about cases, even when they're making a conscientious effort to reach the right result. It doesn't necessarily translate in the way opinions are written. I do. I think that I think the court's opinions have become greatly hyper-technical. For example, you will see in opinions elaborate citation to prior cases. When you're at oral argument, you don't hear the justices talking very much about prior cases. They're talking much more about consequences of ruling one way or the other, or larger issues. They don't think about what other justices who are no longer with us wrote years ago. They're trying to decide the case now. The opinion comes out, it's all full of precedent and case citations, and I don't think that's what moves the court. In many ways, if you want to know what moves the court to decide cases the way they do, listen to oral argument, which is much more like the Supreme Court's id. Opinions are like the court's superego, written by the, often drafted heavily by the law clerks that don't always necessarily reflect, what's motivating the justices, much of which you can hear at oral argument. For example, when the Affordable Care Act was argued, a number of the questions asked by Justice Alito and Justice Scalia seemed to be reacting in a hostile way to the fact that they saw the act as a redistribution, which really had nothing between young and healthy people and older and sick people, which really had nothing to do with the issue about whether it was an appropriate exercise of the commerce power. And as the Solicitor General noted, Social Security Act was a redistribution. But you don't see any of that reflected in the opinions in the Affordable Care Act cases. You see it reflected in the oral argument. So if you want to understand the court, either in addition to or instead of reading the opinions, listen to the audio of the oral arguments, which you can click through to on SCOTUSblog. I don't know why the court has changed in terms of opinions, but I think 4 law clerks is probably too many. Yes, the term I clerked, we decided 168 cases by full opinion. Now, the court did not necessarily decide all those questions well, and mistakes were made in the opinions, and I'm sure having fewer cases and half the number of cases and twice as many law clerks means that fewer mistakes are made in the opinion writing process. But there was, I think when there were 2 law clerks was much more a collective enterprise of the justice and the law clerks, perhaps, than it is today. I think the court could use justices with more experience in politics. If you take the court that existed the day the Brown decision came down in 1954, every single member of that court, every single member had played a prominent role in national public life before going on the court. Every single one. There were 3 former attorneys general, 3 former United States senators, the most influential 20th century governor of California, at least before Reagan, and Earl Warren, who had been a likely presidential nominee of his party. So senators, attorneys general, presidential candidates, that was the court. Now, that court needed some professionalism, and when Eisenhower named John Marshall Harlan, a distinguished New York attorney, that was a useful balance on that court. But now, no member of the court played a prominent role in public life before going on the court. None. The Warren Court, the Brown Court in 1954, not a single member had been a judge before going on the court. There was no prior judicial experience, none on the whole court. Now, virtually every member of the court had been a judge, except for Solicitor General Kagan, had previously been a judge, and I think the court is missing some sense of how politics actually operates. I mean, to me, the big loss that came when Justice O'Connor left the court is not just that it lost an influential woman, but it lost the only member of the court who had held elected public office, who'd run for public office, who'd been part of a legislature, who'd been part of the horse trading that goes on in the legislature. And I think the current court treats Congress as if it were a federal district judge, doesn't have the kind of respect for the institution of politics. And I think the notion that a court should be made up of 9 appellate judges, many of whom had been professors in their prior lives, like Scalia and Ginsburg and Breyer, Kagan, good justices, but I think that's a very limited range of backgrounds compared with those who had served in the Senate or been governors of the state and or played prominent public roles like Thurgood Marshall played. And so presidents have a hard time finding the right political figure. I know that President Clinton wanted Mario Cuomo to be his first nominee to the Supreme Court, and Governor Cuomo wouldn't return his phone calls. I was in the White House at the time. But I think it's somehow hard to find the right person with political background. But the notion that people going on the Supreme Court needed to have been academic scholars and need to be able to recite what they know about 75 or 100 Supreme Court opinions to the Senate Judiciary Committee makes me think we're really getting on the wrong track in terms of the model. I think a mix is best. To have some academics. There's very little on the court in terms of people who have actually practiced law in the trenches. Both Justice Ginsburg and Chief Justice Roberts were appellate advocates. But only Justice Stevens was the last person who had a real great big law practice as he had had. And even then his law practice was in days when law practice was much more genteel. I mean, the court has to make decisions where there is no precedent. To be a lower court judge is to follow precedent, to follow, you've got a hierarchical court that you're responsive to. The system works best when lower court judges are fitting within the law as it exists. Questions come to the U.S. Supreme Court because there's not a ready answer in most cases. So there is more room for judgment. They're not umpires. They're not calling balls and strikes. They're exercising judgment at that level, which is why we call them judges and not umpires. But I think the biographies of the present court have led them to have an extraordinary contempt for Congress and for politics. Politics is not evil. A colleague of mine once said, politics is the way we govern ourselves collectively if we're not going to be a tyranny. And so I think the single greatest shift between the court on which I clerked and the present court is the degree to which the court respects the judgment of other branches of government. And the Warren Court is portrayed as being activist, but it was providing a criminal procedure code where no state legislature had even provided one. Individual police departments were making up their own laws. It dealt with a system of racial oppression in the South that was clearly contrary to the Civil War amendments. But it deferred to and respected the judgments of the national legislature. This court treats the national legislature with the back of its hand, and unless the national legislature jumps through certain hoops, it gets no respect from this court. I mean, to me, the most striking decision of the current court is Shelby County, where the court invalidated one of the key provisions of the Voting Rights Act, and treating Congress as if it were a recalcitrant pupil for not updating the coverage formula, as if the court didn't understand that there were powerful reasons for sticking to the historic formula and not making fresh accusations about which jurisdictions are racist now and which are not. Just stick with the traditional formula for which states have to, get permission to make changes in their voting rights laws where there's been a history of discrimination. So that I think that is one case among many that stands for a lack of respect for the institutional role of Congress. Well, I think the background of this set of justices makes them less inclined to respect the work that Congress does and the hard work of politics. Well, to ask whether the court is a political institution, I don't think the court is a partisan institution. But I think the court, in making judgments about what a phrase like a law respecting the freedom of speech means, or what constitutes equal protection, or privileges and immunities, obviously judgments like that have to be infused with your sense, sharp or vague, about where justice lies, what constitutes equality, what is the freedom of expression, and to what does it apply, and what are its underlying purposes. It's simply not a matter of answering questions as if you're taking the LSAT, when the court is operating. Now, this is a very well-informed court. I mean, I think in terms of being an advocate before the court, there's probably never been a court that is sharper, more intense, better prepared, more probing in its questions of advocates than this court. I think not at a time in the court's history has there been a court that has been this smart in that sense. So that I think most people who argue before the court will tell you that it is almost impossible to get through an oral argument. When there's a weakness in your case, it's almost impossible to get through an argument before this court without one or more justices exploiting that weakness and questioning you about that weakness. Well, look, I think to have a different mix of justices would lead to some broader questions, and questions that really go to the heart of what the court's doing. When the court's deciding voting rights cases, a larger perspective about the historic role of Congress. And Congress being the central institution that the Civil War amendments Congress is the central institution that the Civil War amendments were intended to empower.